Hi, my name is Kieshary Morrison, and today I would like to discuss with you the extent in which employees have right to social media privacy. Employer intrusion into the private lives of their employees is on the uprise as more employers take interest in social media scans for surveillance and screening purposes. Employers are permitted to research candidates' lives and reputations via social media to ensure an employee is a good fit to invest in. Furthermore, if the employee did something egregious and their behavior posed a reputational threat to the company, an employer could lose their credibility or worse, be sued. That is all the more reason why employers should and legally can find out all they need to know about who they are hiring. Given that reality, what are some things employees have rights to? And what should they be doing to ensure their publicly available information will help them land a job? Today, I aim to enlighten you on current laws that guarantee employees' privacy, but also protect employers' hiring and firing privileges, with hope that your online behavior does not lead to workplace consequences, considering what you do in your personal life can and will affect your professional lives as well. One of the most important things to consider are the photos you post of yourself on your social media accounts, because it is the first and most obvious thing employers are exposed to when conducting a social media scan. In fact, a 2014 study of hiring professionals in New York found that employers paid attention to the connectedness between an applicant and their profile picture as a way of inferring professionalism. Now, I'm not quite sure about all of you, but my profile picture isn't exactly Sunday best. However, I am not all that concerned with the findings because the validity of their inference has yet to be established. But that is just one example of how social media scans influence employers' hiring decisions. One study actually found that 45% of surveyed employers research job applicants using online social networks, and more than a third of them found content on applicants' social media profiles that caused them not to hire the applicants. Therefore, posting photographs of alcohol, drug use, or any objectionable content may not be such a clever idea, considering organizations are increasingly monitoring social media for information that might provide insight on prospective hires and current employees. The danger of social media monitoring or background checks is that the information search may be a backdoor to illegal discrimination against employees for legally protected characteristics, such as sexual origin, race, or religion. In one case, Oliver versus Winnie-Dixie LA Incorporated, an entry-level supermarket staff was let go after his supervisor learned that he enjoyed cross-dressing like a woman in private. Peter had worked for Winnie-Dixie for 21 years, during which he showed up on time, did a respectable job, and followed all the rules. But in January of 2000, he was fired because he cross-dresses off-duty. Relevant to the discussion here, this is a perfect example of how problems arise in the workplace when professional and personal lives collide. A survey conducted regarding employee attitudes towards online privacy even suggested that real harm, defined as physical, economic, or reputational injury, could result from work and personal life integration. If unregulated, social media vetting may lead employers to judge candidates unfairly and illegally, which is why many states have enacted legislation to help avoid cases of discrimination. None specifically that govern the intersection of social media and workplace privacy, but prevents retaliation against a person who refuses to disclose a personal or social media account information. On December 28, 2012, Michigan Governor Rick Snyder signed the Internet Protection Privacy Act, making Michigan the fourth state to enact a social media privacy law regulating employers. In explaining the reasoning behind the law, Governor Snyder stated, Cybersecurity is important to the reinvention of Michigan, and protecting the private internet accounts of residents is a part of that. Potential employees and students should be judged on their skills and abilities, not private online activity. The IPPA therefore prohibits employers from requesting access to social media accounts of their employees, such as Gmail, Facebook, and Twitter, and also forbids an employer from discharging, failing to hire, or penalizing an employee or applicant for declining such requests. The IPPA similarly prohibits educational institutions from requiring the same information, and violations of this law can result in a misdemeanor fine and would also allow aggrieved individuals to bring a lawsuit seeking damages at attorney costs and lost wages. Several exceptions to the IPPA exist that are important to note, but for now, I only want to highlight a few that us Michiganders should be mindful of. First, an electronic communication device paid for in whole or in part by the employer is not subject to these limitations. Therefore, be careful not to access social media sites or disclose personal information that you might not want to share with your employer on company-owned devices. Secondly, the Act does not prohibit employers from disciplining or terminating employees who take confidential and trade secret information without authorization to do so. In fact, on a case relevant to these measures, O'Connor versus Ortega, the Supreme Court stated that a warrantless search by an employer is reasonable if it is conducted for the investigation of work-related misconduct. In summary, the law provides minimal protection of social communications of employees, whether on or off the job. Fourth Amendment law cases even suggest that while expectations of privacy may be reasonable, several factors, including employer interests, cut against a finding of reasonableness. Given the legal protections afforded to companies who vet the social media accounts of current and prospective employees, here are a few final suggestions that I would like to leave you with to help ensure your off-duty behavior does not negatively impact your employment opportunities. Number 1, remove unattractive content from your profile or delete your account entirely when seeking out new job opportunities. Social sites such as Facebook even allow you to deactivate your account temporarily without losing memorable pictures or connections with your friends and family. Number 2, make no mention of your place of employment, confidential work information, or discuss encounters you may have had at work on your social media accounts. And number 3, finally, adjust your privacy settings accordingly so the unauthorized users are unable to view your page in its entirety. As Allison Green, founder of axamanager.org, once said, to people who don't lock down their accounts because it's never been a problem, I say, you don't know whether that's true. Thank you all so much for listening to my video. I hope you learned a lot about employee privacy as it relates to social media, and I want to thank you for listening again. Have a great day.